The Michael Sussmann transcripts are out. These covering the oral arguments that took place on Wednesday, May 4th, 2022. We know trial is scheduled right around the corner on May 16th. The court is trying to finalize and hash out remaining issues. And we had a lot of people who were involved and here present. Remember, we've got Michael Sussmann, Hillary Clinton's former campaign lawyer, charged by John Durham, special counsel, with lying to the FBI, said that he had information about Donald Trump and Russian collusion when really he was there on behalf of Hillary Clinton. He has his defense team there. Of course, we've got Sean Berkowitz, Bosworth here representing Mr. Sussmann. But it's not just him. He's the only person charged with the crime. But what is happening is the defense and everybody else who's interested in this issue, they don't want John Durham to get access to certain information. People like Rodney Joffe then hired lawyers, people named Stephen Tyrell at a law firm in DC, to jump in on this criminal case and say, Your Honor, I think that you should not look at this information because X, Y, and Z. We also have two people from FusionGPS, Glenn Simpson and Peter Fritsch, who had their lawyers there at this oral argument to argue that they also had an interest in keeping this information out of the judge's hand. And I should back up a little bit on that. This is all about whether the judge should be able to see this information or not whether the prosecutor should see it, just the judge. Durham and the prosecutors have said, Your Honor, we think that you should compel Hillary and Fusion and Sussmann and Perkins Coie and all these other people to give us information. I'm sorry, to actually give you information, and then you can decide if you should give us the information. Not saying that they should get it directly. They just want the judge to look at it, and maybe the judge says, no, you're not entitled to this, Durham, get out of here. Or maybe he says, yeah, actually, you could be entitled to this. All of these people here, they don't want the judge to even look at it. And our final people who were at the hearing were Robert Trout on behalf of Hillary for America. Lisa Moyera is the court reporter. And then we've got the prosecutors who we have been following, Andrew DeFilippis. But today, a lot of these arguments are being conducted by Jonathan Edgar Algor. And we have a couple other prosecutors who are there, 4 in total. We also see for Sussmann, he's got 4 lawyers, all from Latham and Watkins, and they're from New York. And remember, this is all taking place in DC. So 4 lawyers, big high-profile defense lawyers from New York, flying out to represent little old Michael Sussmann. And do you think that Michael Sussmann is paying for this representation for 4 lawyers working on this case day in, day out, night and day, to make sure that he gets acquitted, or at least this thing doesn't spiral out of control? Do you think that Sussmann is just paying for that? You think he's dipping into his 401k to come up with some funds and resources? Or do you think that maybe he has access to, I don't know, the entire war chest of the DNC? Probably the latter. So they're there and they are doing a good job. They are really putting up a bunch of roadblocks and speed bumps to try to stop this thing from spiraling out of control. And remember yesterday we talked about the Mindmap, a tool that we use when we cover federal cases because they don't broadcast anything. We can't see what's happening in there or listen to the audio or rebroadcast it. So we have to put it all together after the fact, and that's how we do it here. But yesterday we talked about the high-level overview on what's working here, how this is actually functioning. And remember, the argument is about whether the information that John Durham wants the judge to look at, whether it's privileged or not, whether it's attorney work product, whether Durham can be precluded from seeing it, because we have all sorts of protections when you are working on a legal case between a client and a lawyer. We all see it in the movies, an attorney-client privilege and in TV shows. But it's very important and very powerful because we want to protect the sanctity of that relationship. So what's happening here, as we can see, is Perkins Coie, which was the law firm where Michael Sussmann worked, where Mark Elias worked, they went out, they hired FusionGPS, which worked sort of under their wing. Perkins Coie was hired by Hillary Clinton, and so you've got sort of that attorney-client relationship there. You've got the Sussmann FusionGPS relationship, maybe is protected by attorney-client privilege or not. Durham is saying it wasn't attorney-client work that was happening. What they were doing is creating a bunch of hoaxes. If we open up this entire branch, we can see that Rodney Joffe, tech executive number 1, Christopher Steele, the Steele dossier, all of this stuff was being conducted by FusionGPS. And so if FusionGPS is actually kind of writing fictional narratives like Harry Potter books about Donald Trump and Russia, well, That's not really legal work, is it? That's sort of oppositional research that is not protected by that attorney-client privilege doctrine. And if that's the case, if it's precluded or sort of excluded from that protection, then Durham may get access to a lot of those documents that they were intending to have been shielded by this attorney-client privilege. So it'd sort of be severing this chain a little bit. There's this sort of big force field that exists. They're holding a lot of documents hostage behind it. Durham is saying, Judge, you should take a look at it. Judge Cooper, take a look at it. Tell me if it really is attorney-client privilege or work product privilege information, or whether we can get that stuff. The judge, as we know, as we talked about previously, has in fact granted that. He says, you know, I am going to take a look at this, and we'll get there. Of course, that's at the end of this oral argument transcript. But what we're going to glean out of here is that the judge is kind of hesitant on some of it. And it's going to be a little bit limited, and we can really tease out how the judge is going to rule, because even though the judge is going to look at it, doesn't mean that Durham's going to get any of it. The judge may say, well, you know, these defense arguments are pretty good. I kind of want to see it. And that was the argument I made last time when we talked about this. There were all of the written motions by Hillary, by FusionGPS, by Rodney Joffe to stop the judge from even looking at it. And I said, I'm not sure that's going to fly, because the judge wants to look at it. Wouldn't you want to look at it if you're the judge? You say I can't look at it, but I am a judge after all. And I worked really hard to put this robe on. And that means I get to look at things. So he wants to look at it. And of course, he ruled that he will be looking at this. But we can still go through this transcript and see really what happened here. So we rewind the clock. We're back there. Oral arguments are taking place. It is now May 4th in the DC Circuit Court. Says here, from the courtroom deputy, Your Honor, this is criminal case, United States of America versus Michael Sussmann. Starting with the government, please approach the podium and introduce yourself for the record. So the prosecutor takes the podium. His name is Mr. Algor. Says, good morning, Your Honor. Jonathan Algor here, along with Andrew DeFilippis and the other prosecutors. Court says, good morning. Good to see a new face up there. Haven't seen you before, because last time we had Mr. DeFilippis. Algor says, same here, Your Honor. Very cordial. Mr. Berkowitz is there for the defense. We see his photograph here, how he flew in from New York. And these two, the judge, Cooper, and Mr. Berkowitz, seems like they know each other, because they had a little bit of nice conversation, back and forth banter when we started covering this. Says, good morning, Your Honor. You know I'm here with Mr. Bosworth and others. We have Mr. Sussmann, who is also present in the court. Sussman's sitting over there. He's like, another court proceeding, shleesh. And Cooper says, okay, good morning. And says, good morning, Mr. Sussmann. Mr. Sussmann says, good morning. Court says, I trust your commute went a little more smoothly than last time, eh, Sussmann? Sussmann says, yes, period. He's not going to have it. Not getting into it with the judge today. Court says, okay, good. So maybe he had court trouble or something last time. Judge says, all right, how are we going to divide this up here, Mr. Berkowitz? We've got a lot of players here today. Defense Berkowitz says, yes. So we've spoken with all the relevant constituents, Your Honor, and obviously the government is going to speak on their behalf. We don't need to loop them into any of this. Says, I will speak briefly on behalf of our client, Mr. Sussmann, and address any questions you have with respect to our filing. And remember that we're only here for a criminal case. This is Michael Sussmann is being charged with a crime. If you're a defense attorney, that's like your sole job, your responsibility is to make sure this guy does not get convicted of a charge, of a crime. Hillary Clinton and all these other people, theoretically, you care less about their interests because you've got a solemn duty to your client. So here, Berkowitz is kind of saying that. He's like, well, I mean, I got our arguments to make, and then I'll turn it over to them. Mr. Trout is here on behalf of Hillary. We got Mr. Levy is present. He is here on Fusion. Steve is here. He's going to talk on Mr. Joffe. And so they can defend themselves and make their own arguments as to why you shouldn't look at this stuff, Judge, but I'm just here for myself. He says there are other people here on behalf of Perkins Coie and the DNC also, that to the extent you have questions, they're here to address them, because Lord knows they don't want you to look at it either. Otherwise, well, they're not planning to speak unless you need them to. Court says, all right, my goodness, that's fine. We got a full house here. It's like the entire Democratic Party. Says, what I'd like to start with are just a few clarifying questions here, just for my benefit. Appreciate you offering an agenda for us, but here's how I want to start. Says, from Fusion, we're going to start here. Then we'll hear from the government, because of course it is their motion. Durham is asking that the court compel Hillary and basically the entire DNC and their lawyers to give up documents to the judge so he can look at them and decide whether they're protected or not. So he says, all right, we're going to start with Fusion because you're kind of the centerpiece of a lot of this. And remember, when we go back to the mind map, we recall that they were this company that were creating these inquiries, these investigations that involved Rodney Joffe. We see him here. People like Christopher Steele. We know that they were founded, the organization founded by Peter Fritsch, Glenn Simpson. They were hired by Perkins Coie. Perkins Coie is right where Sussmann worked. Many issues that came out of Fusion and Perkins involved the Yoda phone story, Alpha Bank, Paul Manafort, Carter Page, all this stuff from FusionGPS. And we've heard that name all over the place. So the judge says, all right, listen, this is a pretty key branch here. When we're talking about FusionGPS and attorney-client work product and protected information, this is kind of that sacred bond here. A lot of this, if we can say that this entire connection between Perkins and Fusion is really 100% protected work product type relationship, and it's kind of the end of the story. We really don't need to talk about much else because a lot of this is their documents. So he says, let me just dig in on that. And this is where it starts. And before we dive into the transcript, I want to thank, as always, Technofog for pulling the transcript. So I always like to reference them and make sure we support them. He's over on Substack at The Reactionary. It's, if you just go to Substack, type in Technofog, you'll find him. He's on Twitter, does amazing work and analysis. He did a whole analysis here at The Reactionary where he actually goes through the transcript. And so please go subscribe to him and support his work. He's doing a great job as well. But he provided the transcript. I added the photographs. And then it all comes together. So thank you to Technofog for the transcript. So judge says, all right, so just so I'm clear, Fusion asserted the privilege over 1,500 documents. Is that right? In response to the first two subpoenas that it got. So the judge is saying, let me be clear about this. FusionGPS, you're here. You got a subpoena way in the beginning on this case for 1,500 documents. And this is what we're complaining about. You're saying you've got privilege over this bucket of information. Attorney for Fusion comes out and says that's correct at the direction of the privilege holders counsel. So Fusion is saying, yes, the people who are actually asserting the privilege are the privilege holders. Court says, all right. And we're here today to talk about 38 documents that the government would like me to review in camera, but I take it Fusion asserted privilege over more than the 38. You asserted privilege over the 1,500. Is that right? Fusion says, yes, that's correct. So Durham is really not asking for all 1,500, only those 38. Court says, but you produced a number of documents as well, didn't you? So you actually did disclose stuff over to Durham. Obviously, I've seen emails from Fusion employees to members of the press. You know, a lot of this stuff has been made publicly available. And so you have disclosed something, haven't you? How many documents then did you produce to special counsel? So what did you give them? Mr. Levy, the defense for Fusion, says, we produce hundreds of documents, thousands of pages, and I don't recall the exact number, Your Honor. So judge says, okay. So apparently you can give them some documents. And how did you make the draw between the privilege assertion and the documents that you produced? In other words, what documents were protected and not protected? And how did you decide? Basically, the judge is saying anything that went to a third party, you produced, and internal emails you withheld. Was that your process? Is that fair to say? So if you had a document that sort of went outside of the company, you said, all right, well, that went outside of our company and therefore it's sort of now public. And so we just turned that over. But the internal stuff you withheld. Is that right? Defense says, well, we shared the documents with counsel for the privilege holders, and the counsel for the privilege holders here, it's the DNC and HFA, as well as Perkins Coie. So that's the Democratic National Committee and Hillary for America, the law firm that represented both of those clients, Perkins Coie. So we sent it over to their lawyers. The privilege holders are the DNC and the HFA. And so kind of what's happening is FusionGPS is saying, we don't really have any, authority to waive their privilege. The holders of the privilege are the DNC and HFA, not us. So we sent it over to their lawyers. And so we can't be responsible for what happens with these documents. They're sort of passing the buck. They reviewed those documents, their lawyers, and they made judgment calls about which documents were privileged. And we followed those instructions and included the privileged documents in a log and produced non-privileged documents. So we just did what their lawyers told us to do. We don't know any better. He says there were some internal emails that were privileged, and Cooper jumps in. The judge says, okay, and Levy says, because they were communications and they were work product conducted during the period of engagement between Fusion and Perkins Coie, pursuant to a letter. Judge says, okay, so with respect to the internal emails that were generally withheld based on privilege, so the stuff that you did not give out, there have been a lot of discussions in the briefs as to the role of your company. So you're keeping these things internal. And our question is, well, why? And what were you doing? And what were those emails about? Whether it was playing the role of a consultant or advisor to Mark Elias for the purpose of providing legal advice, or according to the government, whether it was doing something that is not protected, like engaging in opposition research services or public relations services or interactions with the press, which of course is a lot of what they were doing. So the judge says, we've got these two categories, and you've got these internal emails. And what we're trying to do is take this big group of emails that you say are protected and really sort of filter them out. This is actually protected. This is not actually protected based on the type of work that you were performing. Says to Mr. Levy, was there any effort made by the privilege holder to review those internal emails based on the two potential roles that Fusion could have been playing in this case? So the judge said, I just defined these two buckets, sort of legal work and the other sort of campaign work. And he says, did you give those two heuristics, those two filters to the DNC or to Hillary Clinton and communicate that these are the legal standards that might apply? Saying, if we do this type of work, that's kind of not the legal stuff. That's sort of the campaign stuff. Did you communicate that to them? Mr. Levy says, well, it's a good question, Judge. It's kind of an important question. In fact, says, I think that question is probably best addressed to counsel for the privilege holders because they were the ones reviewing it. So Fusion doesn't know anything about that. As I said, we were giving it to their lawyers, then their lawyers did something with it. So he says, it's my understanding that they're looking at those emails with an understanding of what the purpose of the engagement was and whether the purpose of Fusion's work was for Perkins Coie. So they didn't really go into the specifics. They just said, it really doesn't matter what FusionGPS is doing. They're working for the lawyers. Therefore, whatever FusionGPS is doing is legal work by virtue of the fact that they're doing it for lawyers. And the lawyers are managing all of this, and they should know better. And they went to law school, and they're very smart, and they got a law license, and they got stupid diplomas on their wall, like me. And it is something that makes them responsible for the work that their experts and consultants are doing. You can't just hire a consultant. They go out and break the law and do a bunch of stuff. And they say, well, they're working for a lawyer, therefore they're immune. No, it doesn't work like that. And here, Fusion is sort of saying, well, so we just deferred a lot of that over to Perkins Coie. And now Perkins Coie, ask them about it, Judge. So he says, but I would recommend that. I'm happy to. I have some knowledge of that, but I think it's probably best to talk to them. So the judge says, all right, that's fair enough. It's a good point there, Fusion. So let's clear that up. That's out of the way. He turns it back over now to the prosecutors, Mr. Al Gore. He says, all right, you're up. Al Gore, prosecutor from Durham's team, says, thank you, Your Honor. And here we are. The government submits, and this is why you should see this, Judge. He's saying this is why you got to take a look at this. Not necessarily that we want it or that we should make this public or disclose any of it, but you should look at it. Why? It says there is a adequate basis for Your Honor to review in camera the 38 messages that we put in Exhibit A. In camera meaning in the judge's chambers behind closed doors, outside of the public, outside of the parties. He writes or says, the parties here advance a very broad, novel theory of attorney-client privilege and work protections. Here are the parties. He's talking about all of these people here. DNC, Hillary, we've got Fusion, we have Rodney Joffe, tech executive #1, saying that FusionGPS opposition research, which clearly you can tell from the privilege logs is exactly what they're doing within this, is somehow protected under the attorney-client privilege, which is based on the agreement that was entered into between Perkins Coie and Fusion. And he says, when you look at that agreement and the materials that exist between Perkins Coie and FusionGPS and the privilege log and the subject headings and everything that they're participating in, he says nothing shows that this was based on any legal advice or any even consultation and providing expertise to Perkins Coie so that they could provide legal advice to Hillary. So it wasn't legal advice at all. And the court says, all right, so do you dispute that one of Fusion's roles, at least one of them, or one of the purposes of its engagement, something it point all was to inform Perkins' advice to clients about whether certain pieces of information were true or plausible for the campaign to comment on. So the judge is saying, well, let's put ourselves in Fusion and Perkins and Hillary's shoes. If you're Hillary and you're running for president, you probably want a law firm to advise you on political issues so that you don't go out and say stupid things on the campaign trail, like you can do something when you can't do it because there's a constitutional provision that prohibits you from doing that thing. Although that doesn't really matter too much these days anymore, but you get the point. You'd still want lawyers on counsel, on standby, on retainer, so that you could ask them policy questions. And you'd also, if you're going to be going and attacking a political opponent or something like that, you might want an attorney to say, you know, if you say that, you're going to get sued for defamation or for libel. You can't say something that is blatantly not true about this figure because there might be actual malice behind, and you open yourself to liability. And so you want maybe a research team to say, well, you know, this claim came in about Donald Trump and Russian collusion, and so we better vet it before we start running our mouths and making posts on Twitter. And you vet it so you don't spread a bunch of fake news. In this case, they didn't really do much of that. We all know that they were sort of creating the fake news and then spreading it to the media. It caught wind and really dogged Donald Trump, although he won anyways. But the point is, if we put the hat on the other foot, and it is something we look at in a light most reasonable to Hillary Clinton and Sussmann and Perkins Coie, you might see a situation where you want a campaign, a law firm, and a research consultant to go out there and support the campaign legally. But did that happen here? Let's see. And if that was something that happened, and we do hold that in a light most reasonable, light most favorable to that non-moving party, which of course are all these people, they don't want the judge to see it, well, then we have to kind of give them the benefit of the doubt and presume that some of this might in fact be privileged and protected. So the judge says, well, look, I think in theory, yeah, the prosecutor says that's exactly what the engagement was meant to be. So like, yes, should have been that. It is that exact structure that I just detailed. In theory, judge says, okay, so you acknowledge that maybe there is some attorney-client privilege and some work product here. Judge, okay, all right, thank you, Mr. Al Gore, reasonable. Mr. Al Gore says, I would, and the court jumps back in and says, and do you think Fusion did work towards that end? So now that I've got you acknowledging it, how about that? Maybe some of this is privileged. And the judge is playing devil's advocate, trying to poke holes in the arguments of both sides. Says, well, prosecutor writes or speaks now in oral argument, says, it's hard to determine from our vantage whether they did so based on, because we can't look at the underlying communications. We can't see. But I mean, when you look at the declarations based on Mr. Elias's declaration, Mr. Mook, who also worked for Hillary, and we've actually interviewed him as well, says in each of those, they were taking measures to shield and keep those protected materials from discovery. But they were not providing, Mr. Mook says, they were not providing specific legal advice regarding that, regarding this or this defamation or libel. But instead, they were providing research that was promoted and then clearly was promoted throughout the news media, which was not legal advice. That's campaign relations. If they're sending the memo to the lawyers and the lawyers are sitting down with Hillary and saying, listen, you know, here's the thing. And then Hillary takes that news and they send it over to the media and they say, we've vetted this. It looks good. Why don't you guys vet it and run with it? But that's not what was happening. This was all being funneled through Perkins Coie to FusionGPS, and they were directly interfacing with the news media. So they were acting more as a PR firm and a campaign advocate than they were any legal support expert or consultant. So the prosecutor is making that argument, and the court says, that's probably a pretty good argument, but says, let's put that promotion to the side because we got to tease out the meatballs from the meat sauce. Says, let's put the promotion here issue to the side. And, you know, I can't imagine a scenario where Mr. Elias, Mark, picks up the phone and calls Mr. Fritsch or Mr. Simpson, the co-founders of FusionGPS, and says, look, there's this. There are these allegations out there about X, Y, and Z. What do you guys think? Can you do some research on that? Give me a white paper. Give me some background because I need to be in a position to tell the campaign whether you know this is real or not. And so research developed by the investigator would seem to fit in that scenario. It would be sort of in that work product, wouldn't it? And the judge says, look, I'm not saying that's what happened, but certainly it's plausible and factual, isn't it? And it could be consistent with what Mr. Elias has said the purpose of the engagement was. And the judge says, is that fair? And it's very fair. That's right. That's how it should have been. Prosecutor says, yeah, I think that, yeah, within that though, within you look at the Koval doctrine, you know that within that, in that instance, The advice, the expertise they were providing, is this research? That's the question. Is this research legitimate in providing the legal advice, and whether the anticipated litigation would even occur? So you can't just sort of say that everything is for legal advice or for legal services and just lump everything into that, because one portion of it may in fact be legitimate. It doesn't mean that all of it's legitimate. So you got to sort of examine that. There's a framework for that. So the prosecutor says, and instead, what is being done is solely to shield opposition research so that you can't get inside that, because they just claim work product. He says, so this is, and the judge says, well, how do you know that? How do you know that that's solely the reason for that? Prosecutor says, Your Honor, there might be. The court jumps back in. He says, Fusion was hired, and what Fusion did generally. How might you know about that? And they're kind of talking over each other. So prosecutor says, you pipe down at that point. The judge is talking. So, all right. He says, all right, sorry, judge. Finishes his sentence. To clarify, Your Honor, there might be instances where, Your Honor, there may have occurred what you just described. That may have occurred. But what you see by their actions and by the fact they went out to the media and the third parties and the documents that have been produced by Fusion, which went to the media, it shows that it was pure opposition research. There's not even a hint of legitimate legal work under there. He says it was not intended to provide expertise regarding so Perkins Coie could provide legal advice to Hillary. This wasn't this domino effect that was happening. Perkins wasn't gathering this, interpreting it, and then providing the data to Hillary. They were just sort of, go hog wild. You're protected. Fusion, go have fun. Talk to the media, do whatever you want. And they did. So the prosecutor says, I'm not saying there was never an instance where Mr. Elias was seeking out certain expertise from Fusion. But that doesn't mean that everything is protected. But what I am saying is when you look at instances and combined and cabined along with this is the 38 messages that we've identified, which is related to the Alpha Bank allegation. And when you see that Fusion is promoting all that material, it's distinguishable clearly from the situation that you just described, Judge. So we say you described something that, yeah, that could be true and reasonable, and maybe it happened a number of times. But just because that may have happened doesn't mean that everything that they were doing was above board. The court says, and you believe that I would be able to make that distinction by looking at these documents? He said, let's segregate this out a little bit. The first 30, which are all internal Fusion emails, versus the second 8. We're learning more about these documents, which seem to be correspondence between Mr. Sussmann and Mr. Joffe, who appear to be in an attorney-client relationship at some point. Now, Sussmann, a lawyer, talking with Joffe, who I believe is a non-lawyer, but he is the tech executive #1 who is responsible for basically inserting himself into the DNS system, which allowed him to monitor all the traffic for Donald Trump, the actual president of the United States, by the way. Mr. Al Gore says, okay, so right, Judge, we'll do that. We'll split these emails up and from Sussmann to Joffe and the first 30, the internal Fusion emails. Court says, all right, let's talk about the first 30 then. What about the emails based on the privilege log and the info? Do you think I'm going to be able to look at these emails and then determine whether they were created in the aid of, let's call it a fact-checking operation or, a libel function? So the judge says, if I look at this email, I'm going to be able to see it and say, oh, this is clearly attorney-client privilege, or no, this is clearly not. He's saying, prosecutor, if I look at it, I'll be able to make that distinction? And Mr. Al Gore says, well, so we don't see underneath those emails, obviously. So I can't tell you what they actually mean, like where they came from. But the court says, understood. I got you. Okay. Mr. Al Gore says, but I do think that, you'll be able to tell one way or another from how the individuals at Fusion are communicating, whether they're actually doing so to provide expertise to Perkins or whether they're actually creating documents that would be opposition research promoted to the FBI, to Congress, and to the media. I think you'll be able to tell, Judge, is what he says. Judge Cooper says, okay, so let's look at the Exhibit A, the privilege log that you've attached. Let's go through these. What's special about the first 30? He says, why is it these are the ones you want? And why do you want these specifically? The prosecutor responds. He says, yes, Your Honor. And so I think about this, really this gets to what Mr. Sussman's counsel was talking about. We have identified Mr. Seago, who we talked about yesterday. Remember her. She works down here, tech ops for FusionGPS. She's on the team there. Was a so-called tech maven, somebody who's very sophisticated with the technology. And so she's there. And the prosecutors want information from her. We've identified her as a core witness that can talk about the relationships between Fusion, Joffe, Hillary, and Sussmann. And so what we see is, and we've seen through the public records testimony from Mr. Sego about meetings with those individuals back in late August, that she is a technical expert at FusionGPS who is the most immersed of all of them regarding Alpha Bank and the testimony there. So that is why we were focused on Laura Sego and that testimony. In addition, at least one of the 3 white papers that goes into the FBI is being created in and around the same time that Mr. Sego is there in meetings. And that white paper was being created by Fusion. So the court says, all right, so a number of these entries then are all related to that. And says, oh, they appear to either be final versions or draft versions of that white paper. Is that what we're talking about? Prosecutor says, you got it, Judge. Am I reading that correct? Yep, that's right. Okay, and depending on the emails, you may want to introduce them through Mr. Sego, Mrs. Sego. So if you get her in as an expert, as a witness, then you can then get a lot of those documents in. So that's why you want Sego. Court says, all right, that makes sense. I'm following you now. And the prosecutor says, and it's also important context within Mr. Sego's testimony about what FusionGPS's role was regarding the white paper, and also Mr. Sussmann bringing those allegations to the FBI. And then subsequently, the Fusion role in promoting that material to the media. So the judge says, okay, and obviously you haven't seen these emails, and so you don't know what to say, but you think there is a possibility based on the descriptions in the privilege log, you haven't seen them, that they would be relevant and admissible through Miss Sego for that purpose. And the prosecutor says, yes, Your Honor. Court says, okay. After Judge Cooper finishes with the prosecutor, we change gears and go over to Mr. Berkowitz. He says, who's up first? Berkowitz says, good morning, Your Honor. Court says, good morning. Mr. Berkowitz says, we'll be brief, subject to any questions you have, Your Honor. He argues the government chose to charge a case with attorneys and privilege all over the place. Says it's almost a law school hypothetical where it's everywhere you turn. We're going to have to deal with these issues at trial. And it's true. There are lawyers involved all over the place. It's sort of the purpose. It's sort of the structure. You get a lot of protection when you structure things under that big protective umbrella. He says, but our concern is that this motion was filed on April 6th. We're now less than 2 weeks before trial. And while they're talking about 38 documents, the reality is, Judge, if you let them look at all this stuff, well, we're going to have a ripple effect that could cover 1,400 or 1,500 documents. And we've got trial in 2 weeks. Court says, well, don't I have to make a ruling anyways with respect to Miss Sego's testimony? I'm going to have to rule about her, and they're entitled to ask her about what they're going to ask her. And if her counsel claims privilege, well, then I've got to resolve that. So it seems like that's probably going to happen. And so I know that this is just a couple of weeks out, but we've got to get into it. Berkowitz says that's true. Probably would happen, Your Honor. That is an issue that, well, we could have been addressing this a long time ago before we put her on the stand. Berkowitz says, so if we have to deal with that, well, then we'll just deal with that. Berkowitz argues, says, Judge, if you rule and you see that all of this needs to be disclosed, it's going to call into question all sorts of issues. And quite frankly, it's going to be something that's going to prejudice us. We're going to have to go through, reevaluate all of these documents and privileges, and it's going to really harm our case if you look at it and then issue these orders. And so we're just telling you, they filed this late. They're out of time. Trial's in 2 weeks. You really shouldn't look at any of this stuff. If Laura Sego gets up there and testifies about something that is consistent with privilege, then I say that you should just say there's a good faith association here and that you shouldn't allow that to happen. You shouldn't basically look at those documents. It blends into some relevance, Your Honor, and I don't want to mess that up too much. But the concept that Miss Sego is going to talk about the relationships and how they existed, it's unclear what's going to come out, and says the prosecutors have known for a long period of time all this information, that it's out there, and they could have produced it and been able to prove their case or not. And doing so at the last minute is not sufficient. We don't have any time to prepare all this stuff and give it over to them. They charged the case with the information they had at the time. They should be limited to the information they had at the time, and they shouldn't get any more. Court says, all right, finish your thought. Berkowitz says, all right, one other piece, Your Honor. Berkowitz says, what we do know from discovery that's been produced is there was an email sent to a reporter from Fusion. It's cited in a footnote from our brief from Fritsch to Hosenball on October 5th, 2016. And the judge knows exactly what he's talking about. He says, the DNS is not us. Berkowitz says, I'm sorry. Judge says, the DNS is not us. That's footnote in the brief. Which, did the judge just recall that? Does he have photographic memory? Where the heck did that come from? Berkowitz says, yeah, exactly. That's the footnote I'm talking about. The background paper is unrelated to all the alpha DNS. The white paper is unrelated to the DNS information. And so the speculation that it's related is inconsistent with the discovery. So, Your Honor, really, there are counsel here who can talk about their reasons for asserting their privilege. Our main issue is that we are less than 2 weeks from trial. And this is a topic that would have been dealt with a lot differently if we had dealt with it earlier. And we've got cases saying that there is harm that will be afforded to us as a result of this. And so I think that there's prejudice. After dealing with Sussmann's lawyer, Judge Cooper turns over to Hillary for America. She's being represented by Mr. Trout. Mr. Trout stands up. Good morning, Your Honor. Robert Trout here for the Hillary Clinton campaign, also known as Hillary for America, or HFA. Judge Cooper says, good morning, Mr. Trout. Are you hitting them straight these days? Little golf joke there. Mr. Trout says, doing my best, Your Honor. I've got a new hip, though. So it's going to be a while before I get through 18. And remember that he's working for Hillary. So if he doesn't do a good job, he may lose his other hip. We'll see. Your Honor, he says, the government here has an erroneously cramped view of the attorney-client privilege doctrine. They're making this too narrow. It's very expansive. It includes everything that we've ever done. And that's why you shouldn't look at it. He says it's been an erroneously expansive view of the waiver, saying that they are sort of saying these emails to the media and all that waives them. He's saying, no, that's not true at all. He says, I think the problem is that they have this binary choice. You know, it's either black or white or left or right. It's not that at all. It's very complicated and we have to talk about it. He says, and I know everybody's anxious to relive the election of the last year, but let me just hit a few of the highlights. And he goes through, he says, look, in April 2016, when Fusion was engaged with Perkins Coie, Trump was the presumptive nominee, and we get a little bit of a history lesson here. You see, he's just sort of going on a soliloquy here, talking about work product. Finally, the judge says, all right, look, all that being said, I may not disagree with anything you just said, but isn't the question before me here, like, can we just narrow this down about the specific work product at issue or the specific communications? It's either protected or it's not. So thanks for the history lesson, but that's why we're here, right? It says yes. Now, if I spun out in my hypo, like I talked about to the government, and we sort of separate these into different categories, and Mark Elias calls FusionGPS and says, I need some help, and they provide him some help, a lot of that could be protected, right? He says, but you've seen the emails that were produced, and you know, FusionGPS tells a reporter, do the effing Alpha Bank secret comm story. It's hugely important. Forget the WikiLeaks sideshow. That's in an email. And the judge is asking Mr. Trout, saying, you're here for Hillary. Hillary's saying that all of this is attorney work client privilege, work product protected stuff, right? But I'm looking at this email where FusionGPS that was hired by Perkins Coie for Hillary, your client, it says here, they're sending an email to a reporter. Do the effing Alpha Bank secret comm story. It's hugely important. Forget the WikiLeaks sideshow. WikiLeaks hurting Hillary, Alpha hurting Trump. But that's not legal work product, is it? No, it is not. And the judge knows that. That's why he's asking. He says, how is that assisting Mr. Elias in providing legal advice to the campaign? Mr. Trout's like, good question, Your Honor. He says, so I had a feeling you were going to ask about this, Judge. So, Your Honor, Cooper says, well, that seems to be a much more direct, that's assisting a media relations strategy in my book. It's getting the information out into the public realm, isn't it? Trout says, and that has been produced. We gave that over to you. Yeah, it is public, and that's why we turned it over to you. Court says, okay, so that's fine, right? So what if the email that was withheld is talking about, you know, this is the document that we need to get to the New York Times in order to push the story? Wouldn't that fall within the same purpose as the actual communications with the press that were produced? So in other words, you have one email that you turned over that showed that FusionGPS was communicating with the press. What if those other emails are very similar or closely related to that, about that conversation, something that was really not privileged? And so we're having to really tease all this out from one another. The court says, I don't know what they say, so it's hard for me to be the judge of it. And then Mr. Trout responds, yes, I think that's the core problem here, is you don't know what they say, which is why the judge actually rules later, I will in fact take a look at this. Rodney Joffe's lawyers show up, make the same argument. They say, good morning, Stephen Tyrell here on behalf of Mr. Rodney Joffe, tech executive number 1. Tyrell says, nice to see you, Judge. Been a long time. Your Honor, I don't know that I can articulate our arguments any better than you have through your pointed questions to the government, but perhaps I could provide a little context on a couple key points. You know, Joffe stands in a different position than Hillary. These are separate relationships. The 8 emails and the 4 emails, 8 in total, are different from the bulk of the material that are the subject of special counsel's motion. And he provides context about Joffe saying that he had a relationship with law enforcement, went to a lawyer, and that he's an innocent party. He just went to talk to a lawyer to figure out what to do with this really horrible information about Trump. He said he just happened to be connected with Mr. Sussmann. And so he's the privilege holder who hired a lawyer. None of this was nefarious. They were all just doing this to help America survive a possible Trump takeover. And that's why the privilege shouldn't be breached. It all should be protected, is what Mr. Tyrell is arguing. Mr. Levy comes back for a couple of different questions. I just want to address a couple different things. The judge indulges some of that. Finally, we get to the defense wrapping up. Anyone else? Berkowitz chimes in on behalf of Sussmann, says, I have the deposition up. They take a look at some footnotes from the deposition. Prosecutor chimes back in, says, just a few things, Your Honor, just to cover. I want to start with some comments from Mr. Trout, clarifying some of the record. Any other questions? That's all that we've got. Court says, no other questions. I think we're about done. All right, he says. Thank you for the presentations. I'm going to grant the government's motion for the in-camera review of the 38 emails. I don't think that that is a significant intrusion on the privilege just for the court to review them, which obviously was always going to be the case. Now, the judge may decide these are in fact privileged. These are in fact work product protected documents, and Durham doesn't get any bit of it. Let's see if the judge gives us any insight about what comes next. He says, as you probably guessed from my questions, I have no reason to doubt the representations made by Mr. Elias as to the purpose of Fusion's retention. I trust Mark Elias. He's a lawyer. And I don't doubt anything he said. He probably hired them for whatever was legitimate at the time. It says it's reflected in Perkins' retention agreement with Fusion, but that does not mean that all of the activities that Fusion engaged in were subject or protected by attorney-client or work product doctrine. And I do think that there is a distinction between hiring a public relations firm to provide fact-checking and consulting on litigation and the affirmative creation and the dissemination of research about an opposing candidate or business. The judge saying, yeah, there is a difference between the two types of work, writes, this is obviously a very unique circumstance. Usually these issues come up in the business context, not a political party trying to hijack an election. Whether review of the documents will reveal whether Fusion was creating work product that is covered or not covered remains to be seen. I don't know. So we'll see what the emails actually say. The judge wraps up the proceeding, says, all right, if there's nothing else on that, we've got our pretrial conference on Monday. And generally, I like to go over each side's witnesses, as I've got the government's, Durham's people got me theirs. Mr. Berkowitz, if you could provide my chambers a copy of your witness list, I'd love to see it. And Berkowitz says, well, Judge, I believe we have, Your Honor. Court says, oh, you have? Okay, well, very good then. And the same with the exhibit list. We've obviously dealt with a number of evidentiary issues regarding potential witnesses. I'm not going to go exhibit by exhibit, but if there are other categories of material that we're going to dispute about, let me know. Obviously, we can't anticipate every issue, but we should probably try to get through a lot of them. We'll go over jury selection. I have the questionnaire. There don't seem to be many disputes about any of this, which is helpful, and I appreciate that. But I will resolve. I think we asked you all for an electronic version. We'll resolve the disputes. We'll give you a copy of the final questionnaire on Monday, and we'll leave it to you all to make sufficient number of copies. I believe we need 125 at least, but we'll have that number provided to the veneer that comes in on Wednesday. Yes, Your Honor, from the prosecutor. We got a placeholder on the schedule for a SIPA proceeding, SIPA 6 proceeding, which is a confidentiality hearings, essentially to look at confidential documents and decide what to do with them. So a judge says, where are we? Will we need to use that? Will there be any disagreements over proposed or any proposed substitutions or summaries of this confidential stuff? And if so, are we going to have disputes over those? So rather than using the actual confidential material, they're just going to say, well, this is sort of what it describes, and everybody can refer to it, as number 7. We all know what that is without saying what it is. And are there any disputes about that? Prosecutor says, yes, Your Honor, I can speak to that. So here, the following is this argument. We're going to be meeting in a skiff here at the courthouse with defense counsel, which is a secured room where nothing can sort of go in or out. Court says, okay. Prosecutor says, we're going to meet and confer regarding their notice. I do anticipate there's going to be certain issues. Apparently, they've got some confidential stuff. Our hope is that after today, we'll have a limited number of issues and we'll deal through some of that with you. Court says, I've got other matters to attend to, but we could fit something in on Tuesday as well, but I'll leave that to all of you. All right, well, the matter is under advisement and we're adjourned. Have a good day. And so any of those pending issues are going to be resolved in a more formal order, but it sounds like the judge issuing his ruling that he is going to grant the government's motion, Durham's motion. We did a full video on that yesterday looking at the court docket. But now what that means is the judge is going to be able to take a look at those 38 emails and make a decision about whether Durham and the prosecutors get it or not. There's a lot more coming. If you've been following this, you may have missed some of the prior videos we did. And so I'll invite you to check out the full Sussmann playlist, which we'll link down in the description. We've been covering this for months. Trial is right around the corner. And so you want to get up to speed because this mind map that we have here is going to continue to grow. The tentacles are going to get just really numerous. Some might even say cumbersome, but it's going to be a lot of fun. And we'll be able to piece together what is actually happening as Durham calls his witnesses and Sussmann builds his defense, and maybe Hillary or some other people step up their involvement. We'll see. But it's going to be a lot of fun to follow. I hope you join us on that journey. I would love it if you subscribed if you haven't already before you got out of here. And I look forward to seeing you on the next one.